Well, so hi, my name's Leslie Day, and I'm the consultant, human resources consultant for Day HR Consulting, Leslie Day. You know, I worked real hard on that name, but I have had the privilege of being an HR consultant for small and middle-sized businesses for over 20 years, and I've taught at DePaul University. I don't teach the college students, I teach other human resources, managers, VPs, whatever. I've taught there for 20 years. Helping them prepare for our certification test, our national certification test, which is a doozy. It's really hard. And so I have done that for a long time too. So what that does is keeps me up on what the best practices are nationally and for bigger companies, as well as I understand how to drill those down and apply those practically for smaller businesses who are not wanting to hear all the corporate stuff. So today, the beginning of 2022, in the past several years, I've done this for the Lake Zurich Chamber, done a employment law update. We're also here today partnering with the Small Business Development Center of the College of Lake County. So I want to thank Claire, thank you Claire, and Mitch with the Small Business for having me do this presentation today. So before we get into the content, I wanted to tell you there's two handouts. So let me tell you what those are first so you know what you got. The one with the logos for the small business and Lake Zurich, that's what we're going to go over today. So we're going to go over laws that are recently enacted. So if it wasn't that they were effective January 1st of 2022, they might have been in the fall, and just kind of so that you're up on what's kind of new. Then I'm also going to go over some other laws that are a little bit older, but they're not new, just to make sure you guys knew about those. And then I'm also going to quickly just talk about what some of the conversations are that are going on in Washington and Springfield about maybe some upcoming legislation that could be things that we would want to know about or understand how to possibly deal with. So those are guesses, you know, just telling you what the conversations are. So that's what the first page is. Now the second page is a summary that I've used for many, many years. It's a list of the employment laws that you would probably not want to fire an employee for any of these reasons, okay, or not promote them, or make some kind of an employment decision about these reasons, because these are what are called protected classes, or in lingo for HR and legal, they have anti-retaliation protection. Meaning that if an employee comes and says, hey, I think I should be getting paid overtime, why aren't you paying me overtime? That's on here. If you fired them after they came and asked you about that, they could say, hey, you fired me because I asked about overtime. Now somebody should pay me some money, like the Wage and Hour Division or the Equal Employment Commission, things like that. So these aren't all the laws, but it's the kind of laws that practically speaking, you would want to know about, so that if you were thinking, boy, I'm a little unhappy with that employee right now, or I'm not picking them for a promotion, and you're wanting to help them understand and give them a reason, okay, you do not want to have it be one of these reasons, okay, because you could be walking into a risk that that person would use that against you as an improper decision-making reason, okay? And I put in yellow, because it is a little blinding when you look at if there's 75 here on this list. They apply in Illinois and for federal, because Illinois and federal laws apply. It does mention Chicago and Cook County in case you do have employees there, briefly, but mostly it would apply for you guys that are here in Lake County. So this is like a backup document. Okay, then let me just first start talking about that even though I told you that you could have exposures with these laws, that the overall employment law for Illinois is called employment at will. You guys have probably heard of employment at will. Probably know that that kind of means that you've got a lot of flexibility to decide who you want to have be your employees. And if you don't want to have somebody be your employee anymore, you have the right to say, bye. You don't have to give them a reason. You don't have to give them notice. You don't have to pay them severance. But employment at will does not protect you from having a lawsuit or a claim from the government, where an employee would go to the Equal Employment Opportunity Commission, let's say, and say, hey, I was discriminated against, or go to the Wage and Hour Division and say I wasn't paid properly, or go to Osha. We talked a little bit about Osha in recent months here. Go to Osha and say, hey, they're not following COVID protocols, or they're not having my workplace be safe. So when we have employees, you know, they have opinions. They're a lot more knowledgeable than they were 5, 10, 15 years ago about this. So it's important to realize that even though employment's at will, and you want to make sure that your handbook says, you know, and that your offer letter, you want to have in an offer letter to employees that employment is at will. You want to reinforce this, okay? But don't think it's like a ole ole ocean free kind of a scenario, is that you really still have to say, okay, now that I know that I can let the person go, I'm not limited. It's like there's not, lightning's going to strike me if I let that person go. What are my risks, and how do I shore up those risks so that, one, I'm doing things kind of within normal business, you know, practices. I'm understanding if I'm doing something that's not exactly within the law, but I didn't even know it, right? That's why I love doing these seminars, because I want you to not fall into that one. And I would say a huge percentage of the phone calls that I get from companies and clients is asking me about something they were clueless about, that there was a risk. And I'm thinking, oh, I'm so glad they called me. You know, so now we can talk through the pros and the cons, and then they can decide what risks they're willing to take. Okay, I got it. This could happen, but I still want to do it. Good. Now they're making that decision from a knowledgeable standpoint, rather than from a holy Toledo, I didn't know, looking back at it, all messed up standpoint. Okay? So I want you to understand that these are important, but it doesn't limit you in making your employment decisions. Okay? Still got to do what's best for your business. Okay? But understanding the risks is part of running a business and being management. Okay, any questions on that? Employment at will. Okay, good. Then let's go through the laws. Now you'll see that there's like 2 pages of this. So please now know that I have got to really crank through these. The idea is to give you info so you can ask questions. You can ask me at the end of the seminar or later. We also have at the end of the handout an employment attorney who's a new member of the chamber who would be able to ask, you could ask a lawyer about some of the questions beyond what I could help you with perhaps. Okay, so we've got that as a resource for you. Okay, so let's start with number 1. Just starting January 1st this year, any kind of an employment contract that your business might have. Now, first of all, under employment at will, you have no obligation to give an employee an employment contract. So a contract means that it's like a legal thing. Hopefully a lawyer looked at it. Normally, you would just give a new hire an offer letter. And that's not a contract. That's just summarizing what the deal's going to be with you hiring them, right? But in some circumstances, you may want to have an employment contract. You may have physicians that you're going to be retaining. You may have salespeople that you want to make sure they understand what the rules are if they were to leave your organization about hitting up your customer base. Okay? So you only want to do that when you, have a really specific interest or need to do it. But those are 2 areas that are pretty common. Management, high-level professionals, and sales folks are where there is commonly employment contracts. You would not want to do an employment contract for a restaurant worker or for somebody like that, probably. But if you do have contracts, I do need you to contact your attorney, because as of January 1st, you need to change those to incorporate what I have included on here. Contracts almost always have 2 different parts of them, and I'm going to just quickly define what those 2 words are because they're kind of confusing. They usually have what's called a non-competition clause. Non-competition clause says you can't go work for the yoga studio down the street, okay, as a manager. You have to be further away from my facility or do that because you would be competing with my business. So that's a non-compete. It's a geographic, usually window around your business that says, I'd love to have you work here, but just realize the terms of that is that if you were to leave, you can't have another place unless you're down in Barrington or wherever is going to be far enough for your business where the reasonable reach of your clients would be. That's a non-compete, non-competition agreement. Then the other one is a non-solicitation agreement. And these are in this contract that I'm talking about. Non-solicitation is much more common and a lot easier for people to accept, applicants, in that it says, look, if you ever leave this business, you cannot hit up the customers that you got to know while you were here, or even the ones that you brought on, and you cannot hit up my employees and try to take them with you to your new job. Now, a lot of folks are happy to sign that when they come in sales. They get, oh yeah, I got it, yeah. I mean, if I knew your customers because I came to work for you, and now I work for a place right down the street, so now there's maybe only a non-solicitation, not a non-compete. I understand that I got to work with their customers and I can't hit up and solicit your customers or your employees. So those are the two most common components of an employment contract. They are changing now as of 2022. The ones that you have in place are probably okay. Just realize that any new hires, you would want to have the new improved wording. I cannot do employment contracts. You would be talking to the attorney who advised you on those employment contracts. Okay, so that changed. That's probably the biggest one that requires some legal action for you guys. That's why I put it first. Okay. The next one is kind of a soft component. I would say one of the most difficult laws for small and middle-sized businesses to take up and deal with is disability law. We'd all love it if we could all have our employees be 100% healthy every day. But the law doesn't allow us to do that. We are obligated by law to embrace the fact that as long as somebody can do pretty much all of the job, but maybe they got some parts of the job because they got some kind of a temporary or permanent disability, that you need to be a little bending, kind of help in the word that we have is accommodate that maybe, because they have a bad knee, they can't get stuff in the bottom drawer of a file cabinet. Okay. You don't exclude somebody from employment because they can't get something out of the bottom file cabinet. Okay, you would say, oh, we can work around that. So that's accommodating. We usually do that with a doctor slip. Doctor saying, this person has a disability, okay, here's what, I'm asking that you consider, okay, and then as a company, you have a legal obligation to consider that, to talk about it with the employee and the doctor perhaps, and figure out how to make it all work. Now that's assuming they can still do the job, like the big picture job, okay, you don't have to change somebody's role, okay, for doing that. So that's really hard for small businesses, especially if somebody is out sick or they're having surgery or they get hurt and you don't know when they're coming back. And you don't know if you got to save their job and what am I going to do for the short term. It gets real complicated for smaller businesses. Okay? So one, I just wanted to fill you in about what disability law is and that it's very difficult. If you have questions, please ask me, ask an employment attorney. Because this kind of defies common sense. If you're thinking, oh, well, I don't have to do that if they can't, yeah, you kind of do. So this is a very firm law. It's been around 20, 30 years that requires you to be flexible and to accommodate where you can. And if you can't, then you got to have gone through talking to them about it, done a hard line. And I would always advise that if you decide to say, I can't accommodate that you talk to an employment attorney before you do that. Because you want to make sure that you're within the corral of, okay, that fits what the interpretation by the court says, so that you don't know that you're outside of what really is going to be enforceable for you. Okay? So they made a very small change, expanding it. So it's not just somebody who themselves is disabled. They expanded it to somebody now who's associated with somebody who's disabled. So it's always been that if I was married and my husband was disabled, okay, and that was affecting me at work, just some, right? Maybe I had some appointments that I had to help with or things like that. I could not discriminate against me as an employee because my husband had a disability. So that was always been in the law, at least for a long time. Now they've expanded that because a lot of people aren't married or all the other things that could be part of same-sex relationships or whatever. So they've expanded that now to say, or you're associated with somebody. It has to be that there's a strong connection where you would have an obligation to assist sometimes, okay? Now, under number 3, perhaps you guys have all been noticing that the Supreme Court just decided last week that the federal government's mandate, and this is for only companies that have 100 employees or more. So a lot of you might have tuned it out and said, what the heck, you know? Or you're a medical provider who receives Medicare or Medicaid, okay? There were 2 different expectations that the federal government made saying that either of those companies, you have 100 employees and or your Medicare or Medicaid, that you had to have a real policy in place and a procedure so that the vaccinated folks at your company, they were okay, but the unvaccinated folks at your company had to go and get tested weekly to show that they were not positive with COVID, and they had to walk around with a mask. Mask part was not a big deal because in Illinois, we're all supposed to be wearing masks. I'm only not wearing it because I'm doing the presentation here because I'm not eating or drinking. But anyway, so that was not as obvious a thing. There was a lot of pushback when the government announced this expectation in the fall. And the Supreme Court just decided last week that the 100 employee mandate is voided, it's on hold. However, organizations that have Medicare or Medicaid, that rule still applies. So if any of you are medical providers, you might have mandated that all your employees get vaccinated anyway. Okay, that has been around and it's been in Illinois as an expectation. This was a federal rule, and sometimes states have more stringent rules than the federal government. Illinois is an example. So in Illinois, we all have to have masks on. But in Indiana, you know, you don't have to have masks on. We have an indoor mask mandate. That's an Illinois law. It's not a federal law. So what this is talking about was the federal government mandating how it would apply to all the states. Okay? So that's on hold. However, if you do have Medicare, Medicaid payments, you probably would want to get some additional information because that was upheld by the Supreme Court last week. Okay. Okay, so on 4, I just talked about the COVID mask mandate, so I kind of rolled that in. Let's go down to number 5. Okay. This is actually in this section as well as the next section, and it's because I just like to bring it up. It is changing every day at the federal level, not so much at the state level, and I'm talking about using individuals that are independent contractors versus hiring them as like a W-2 employee at your company. So independent contractors, sometimes we call them 1099, right? We have to give them a W-9 every year. W-2 employees, right? So that's a difference. Historically, a lot of companies were like, well, shoot, you know, I don't know how long I'm going to need the person, or maybe it's a temporary need. Let's just have them come as an independent contractor instead of hiring them. And it seemed like there was good reason for doing that. Well, those reasons have been greatly reduced in the last 10 years, last 5 years. And now we have some back and forth stuff going on between the Obama administration, the Trump administration, and now with the Biden administration, where the prior guy's rules are being undone by the current guy. So we have some stuff going on with independent contractor issues. I just strongly recommend that if you have folks that are helping you that are independent contractors, that you're sure that that's legal. The government wants you to have tax money. They want to have it be that they have insurance and all the things that might go with an employee. So if somebody's an independent contractor works with you and they work for another company and they just come in and let's, as an example, say they work on your IT, okay? They come in once a month, okay, they're fine because they're probably an employee, as I said, of somebody else. But let's say they're their own business, okay? There are some pretty big rules. Part of it is under IRS Code 15A. So if you want to look it up, IRS Code 15A, it does give information as to what are some of the conditions that the government would say is okay for you not hiring that person, but paying them as a 1099. And they are back to a very reduced level now that we have the Biden administration. So I can explain that offline to you if you have a question, but it's an area that I just like to mention. There's stuff going on federally right this week, last week about it. There's some stuff going on in Illinois, but more at a federal level right now. Okay. Roland, minimum wage. So I did include in your handout Illinois. The minimum wage now changes every January moving forward. The minimum wage now in Illinois went up to $12 an hour January 1st, and I know that Claire and the Chamber sent out a notice. There is also a youth rate of $9.25. If you're going to have a youth for 650 hours a year or less, you can pay them $9.25, get somebody to work for you. And also if you have tipped employees, like a restaurant or someplace where there's tips, that is now, with a tip credit, $7.20 an hour. Then there's also Chicago and Cook County. If you have employees in Chicago and Cook County, their minimum wage is changing in July still. So next July, it's going to go to 15. Now it's at 14. Cook County's at 13. And then if you are a government contractor, meaning, or federal government contractor, meaning that you get money from the federal government, like contracts that are, like if the federal government buys a lot of cars, as an example. Let's say that one of the multitude of things you make is a little light bulb that goes in a headlamp of a car that's eventually bought by the federal government. That makes you a federal contractor, kind of a small one, okay? But if you do have contracts, they probably ask you if you are complying with Executive Order 11243. That's what they kind of have in the contract to let you know that. But the minimum wage, if you're a federal contractor, is $15, effective the 30th of January. So it goes up to $15 there. Also mentioned in that, they're reverting to the rules on tip pooling. So I mentioned about there's a tip credit if you have employees that are tipped. There's a way that you can pay them less than the minimum wage. That's what tip credit is. Tip pooling is where, like a restaurant would put all the tips into one kitty and then divide it out. And they have rules as to who can be part of that payout. Like the manager can't be part of that payout. Now they're reverting to the pre-Trump rule, so this would have been the Biden rule, about tip pooling that says nobody in the back office or that's not up at the front of the office with this restaurant or whatever, they cannot be part of tip pools. So that just recently switched in November. Okay, on to number 7. Sorry here, I know I'm rolling through it, but number 7 is the Illinois Secure Choice Act, and it's again very important for small businesses to know about this. What the state of Illinois said several years ago was that if your company doesn't have a 401k or a pension plan, you have to notify your employees of this IRA that the state is managing. So the Illinois Secure Choice is an IRA plan that employees of companies, now it has historically been only if you had 25 employees or more, and you had to notify that all your employees, if you don't have a 401k or something like that, that they have the right to participate in this retirement vehicle that the state's providing. Okay? It's a pretty good thing. You know, it doesn't cost the business any money other than having to have direct deposit, having them take money out of their check to go each paycheck into this 401k type thing. Okay, but it's an IRA. They just announced that those numbers are now going below 25 employees. So starting in September of this year, they're going down to 16 employees. And then starting in September next year, they go down to 5 employees. So my point is, if you don't have a 401k, this would be a good time to look at the idea of starting a 401k. Then as a business owner, you have some tax benefit from that. You're kind of providing it rather than telling your employees to sign up for this thing and the state's going to have your money, which is a nice option if you don't have that at your organization. If you're not familiar with the Secure Choice Act or any of that stuff, I'd be happy to explain it. Okay, next one, VESA, number 8. VESA is a law that's been around a long time. It's Illinois specific. And it says, it's kind of like the Family Medical Leave Act. So if you guys are big enough to have 50 employees and to have employees that have employment protection because they've had a personal illness, they adopted a baby or had a baby, or their spouse is sick. There's some reasons that the Family Medical Leave Act kicks in, and that is for 50 employees. Okay, that didn't change. But VESA is kind of like it, but instead of it being about sick or having a baby, it's about somebody who's the victim of domestic abuse. And it allows them, just like the family medical leave, to have an unpaid leave of absence, unpaid. So what it means is you have to give this person the ability to be off work, unpaid, and get stuff straight, okay, with whatever the outcome of this was. So it used to be it was 50 employees. They keep ratcheting down the number of employees that it applies to. So now they have also extended it to include a victim of any kind of violence. Any kind of violence. So assumingly, possibly, if somebody got beat up, you need to give them a leave of absence to get straight. Okay, so maybe they're not disabled, maybe they're not covered under another law, but you need to give them a leave of absence to address that. Maybe they're now afraid, maybe they need to move, things like that. Stalking is part of the domestic abuse stuff. So that's what VESA is. VESSA is the shorten for that. And all of you guys should have compliance posters up at your facilities. So the federal and the state posters, you could get them all in one and get it laminated. That costs a little bit of money. But the only new poster that you have is for VESA. And I brought it so you could look at it. I'd be happy to actually send it to you. You could just put this up, this page, up with your current posters. You don't have to buy new laminated posters. And there are these businesses out there who love to rip you off and say, oh, get the new. No, the federal posters haven't changed in years and years. Illinois keeps having stuff change. You know, it is Illinois, right? So this is the one that has to be put up now. And you could just tape it up next to your other ones, okay? You don't have to get rid of the old ones. So this is a free solution, and you would be in compliance, assuming that the posters you have up, you had them only for a couple years. Okay. If you had them for like 5-10 years, it might be good to get a new whole enchilada. But that VESA is the only new poster that you would need to have up for your employees. Okay, rolling right along. Let's see here. Okay. The Equal Pay Act, 9. Okay. Illinois, for 100 employees or more, several years ago enacted a law making us in Illinois have more requirements for showing that we're paying our females and males the same amount of money, or equivalent kind of money for the same job. And some of those requirements are going to start kicking in. So the first one of these requirements that is kicking in is that if you do have 100 employees or more, you also are probably doing what's called an EEO-1 report. You're going to be doing something very similar to that based on pay in the future. But for this year, you have an obligation to tell the state 3 of your management employees that would be the contact for the emails the state's going to start sending you as to how this is all going to roll out. So just sometime this year, you would need to update them. And that's, again, if you have 100 employees or more. So I'm not going to spend very much time on that. Next one, kind of a brand new, interesting one. Has everybody scratching their head a little bit here. Video interviewing. So big companies sometimes are using artificial intelligence. If you've ever applied for a job, they now look at your resume, pick out like words that are important or that they think are going to be reflective of what a good employee would have on their resume. So they're using software to pull your resume apart, look for info, and then the software helps pick, okay, we're going to interview 5 people of these 200 people that send their resumes in. Who are the 5 people? And this is all done by software. So Illinois said, you know, we don't like that so much. If you're going to be using that software exclusively to figure out who those 5 people are you're going to interview in person, you need to send us the demographic information for all of your applicants. Like anybody wants to send all that information to the state, okay? So just a little mention here, if somebody calls you up and says, whoa, we have this way cool software that you can use for screening applicants, think, uh-oh, they don't have that law in Indiana, they don't have it in Wisconsin, and the salesperson may be clueless about that there's a law here now in Illinois. They're trying to restrict the use of it. Okay, work authorization. Whether you knew it or not, it's always been against the Illinois law to exclude somebody from employment because of their citizenship status. So that's gone, that handout I gave you for 20, 30 years, whether somebody was a formal citizen or not was something that you could not use an employment consideration, unless you're a bank or someplace where you had to. Okay? What you're supposed to be using is this form called an I-9 form. I-9 form, okay? Every employer, no matter how small, you're supposed to be having this I-9 form completed, and that's where the applicant, at that point probably your new hire, tells you, here's proof that I'm legal for you to hire me. And they might have a temporary work authorization visa, they might have a permanent work authorization visa, meaning that they weren't born in the US, but the government said, yeah, you can work here forever. Okay, you can't hold that against them. So this new law is making it clear that as long as they meet the criteria for the I-9 form, you cannot be then deciding about eliminating somebody within that has those documents just because. That would be a risk and would be potential discrimination based on their national origin, their race, depending on what some of that restriction would be. Okay, okay, OSHA. Just going to mention, we could talk about OSHA forever. OSHA is the law that says you have to have a safe workplace. And there's a lot of different requirements. OSHA has a lot of really detailed requirements, like many. So if you're dealing with workplace safety, you have people that are doing any kind of physical stuff, not an office, you should be somewhat familiar with OSHA. And OSHA historically was charging about $3,000 for violation, then maybe 6, 7, 8 years ago, I'm guessing, it went to $7,000 for every violation. If OSHA came to your facility and found something, it's been $7,000 per violation, okay? Now it is up to $13,000 for every violation, and COVID falls under this. So if you have an employee that says, hey, they're not following the requirements for a safe workplace, and they call OSHA, and I don't know if any of you have had it, but last year we had a lot of situations like that. If OSHA did do a violation, write you up for that, you'd be looking at $13,000 for every person. So OSHA is a very costly violation, very costly law. It's very important for you to be familiar with it. Now that's just for a serious violation. If it's what's called a willful violation, meaning that either you knew all about it, OSHA had come here once before and they already wrote you up for it and now the person did it again, or $136,000, over 136 for one violation. The biggest one they catch on is your emergency exit door. So see where there it has the black and red exit sign at your facilities. You need to know where those are and make sure that there's nothing blocking that exit. You need to have a push exit bar, like a bar, so if everybody's running away from a fire, they just have to push that bar and the door unlocks, so you don't want to have a deadbolt on that door. You don't want to have, sometimes it's an easy place to put stuff. You don't want to have anything that's around that door. You want to make sure that that's clear. So OSHA violations, way up. Again, this is now really scary money for most organizations. Okay, so we're getting to the little ones here. Next one, many of you with your open enrollment for your health insurance, if you had it in the fall, there was a new requirement that you give information about your medical group, your group medical coverage, like the policies. So hopefully your broker or Blue Cross or whatever gave you better summaries to use as of the fall. That's what this says, that you need to have better summaries to provide for your employees if you have group health insurance. If you are a hotel, Actually, it also includes truck stops. There is an expanded rule now for actually training employees about human trafficking. So it may seem like something that is not part of what you would think of on a day-to-day basis, but it happens sadly in Lake County. It happens around the world. And some of the places where an employee may observe something that would have given them a clue to call the police is part of now this mandated training. So hotels now have to give training to employees about what might be signs that there was somebody at the hotel that was being trafficked, that was captive, and what to do about it. So that's now a mandated training, okay? Talking about mandated training, you probably all should have done sexual harassment training every year for your employees. Okay, then number 15, this is an interesting one. They changed the record retention law in Illinois so that clearly if you get a phone call asking information about an employee or an ex-employee that you had reprimanded or disciplined, that you don't tell anybody that information if they call for a employment verification or reference or about anything without having given a written notice to that person before you disclose the info. So we got to keep that. We got to keep any information about employees' warnings or reprimands tight. Okay, that's the new stuff. What time is it?
It is 12:50.
Oh, shoot. Okay, so let's roll. Next, these are the ones that have already been around that I just wanted to make sure that you're familiar with. Okay, I think I already mentioned when we were talking about well, maybe I didn't, but Illinois made a law, actually it was in 2019, that changed the minimum employee threshold for discrimination claims. Illinois used to have the federal level, which meant that an employee in most cases could not allege that you discriminated against them based on their race, their national origin, their religion, unless they had 15 employees, okay? And that's why a lot of small companies would say, oh, I'm too small to have these employment laws apply to me. Well, sadly, well, maybe not sadly, but anyway, Illinois changed that to one employee in 2019. So even if you have one employee, you now have risk for all of the discrimination laws, pretty much all those kinds of EEO managed equal employment opportunity laws. So the time for thinking, oh, I'm a small employer, I don't have to worry about these compliance issues, sadly changed in Illinois in 2019. Okay, I just mentioned about sexual harassment training being required annually for all employees. And that means like real training. The state made some PowerPoint presentations that included content that they had to have it as part of the training. But it has to be like a real training, like somebody talking and answering questions. You can't just give the employees those PowerPoints and go, here you go. That's not training. That's giving somebody some PowerPoints. So just in case that turned out to be a problem, some information on that. Okay, recreational marijuana. That was kind of a new thing in 2019. The thing that I want to make sure is that if you are doing pre-employment drug testing only, okay? You cannot have marijuana be one of the drugs that's in that grouping of drugs that they test. You can still test on heroin and on all the other, you just can't have marijuana be in that test. Now your drug testing facility probably knows that, okay, and you're probably not having that be in there, but you need to know to have marijuana be excluded because the law that they created in Illinois only addresses your ability to control stuff when they work for you. So for the marijuana part, if you did marijuana before you interviewed or before you were hired, that's not part of what we as a company can control. So the day after they start, if you were to do a drug test, you could include marijuana. But if you're going to do a drug test at pre-employment, you would not because they did that before you had any authority over them, if that helps, okay? Okay, they also created a law that made it so that asking an applicant on your application form what their prior pay was and benefits is not legal. So all of you should have changed your application forms, taken out where it says how much did you make at that last place and that last place. You got to take that out, and you are not to ask them how much they made at the last places they worked. It's not legal to ask them. Okay. Which complicates a lot of things. That's why companies often will put in their job postings now. The pay is between this range and this range. And then you can say, you know, is that okay with you? If the pay would be between this and this and this, okay, yeah, you can do that. You just can't say how much were you paid per hour when you were at ABC company. And if they offer it, you're not supposed to use it in making a decision. So you want to stop them and go, you know, thanks, but you know, I don't want to know. Okay, but you do have the right to ask if what you're talking about paying them is okay with them. Just not asking them for the information the other way. That's a tough one, huh? Criminal records. In March last year, the state created a difficult, for any company a difficult scenario, if you're doing criminal records checks. So if when you hire somebody or you promote somebody, you're checking out to find out if they had convictions. Okay? A lot of companies do that. Well, the law changed on that in March last year. And it made it so that if you continue to do criminal record checks, you can only exclude an applicant based on what you find was their conviction by jumping through a whole bunch of hoops. So it has really made it so that a lot of organizations are like, oh my heavens, I'm not sophisticated enough, I don't have the administration, you know, to do this. So you can still do criminal records checks. You just can't use the information in the way that you intend to. But there are some exceptions. Sometimes there are certain medical jobs that they have expectation, and those are specifically listed, the titles of the medical jobs that can still have a criminal record check. But just know that you can't just willy-nilly kind of decide, oh, this person, you know, had a theft charge, and I'm not going to offer them the job now. Okay? Only if it meets these really stringent requirements that the state came up with, and you have to give them notices saying, hey, I, you know, am planning on not hiring you for the job because of this. So they have a chance to go check it out, find out, you know, was that really them? Or maybe they say it wasn't them. And there's been a law that it mimics called the Fair Credit Reporting Act, which was kind of the same thing with somebody's credit. 15 years ago, you could ask an applicant what their credit was. You could find out what their credit was. And that kind of became difficult because it's the same thing. Well, what does credit have to do with if I would be a good employee? So there was a stretch there perhaps. But so that has been restricted now for many years. This is now very similar to that, only it's for convictions, for conviction record. Okay, so conviction record actually became a protected class, meaning that you can't discriminate against somebody because of their conviction record in Illinois.
Can you still ask them if they ever committed a felony?
I'll talk to you about that. You would not want to do that because you're walking right into using that information. If you can't use the information and you ask about it, you would have a hard time explaining why you asked. So the question was, can I still ask if somebody has been convicted of a felony? You should take that off your application form. Now there's been a law that's called Ban the Box for a number of years in Illinois, which says that you would not ask, have I been convicted of a felony? Yes, no. Okay, that was supposed to be off your application blank a number of years ago, and the box is that little box that says yes or no. So we were supposed to have been not asking that information. But as of the first interview in Illinois, you could give somebody that release for having a third party do your criminal background check. You could have them say, yeah, I authorize you to do a criminal background check. And you send it into the background checking company and they do it for you. Usually that's how you would find out if somebody really had a conviction or not, is you'd have a third party would have checked and not just checked in Lake Zurich, they would have checked, Illinois, federally, stuff like that. The problem we have now, though, is that if you do find out even in Tennessee that they had a conviction, and you're like, oh, you can't exclude them without going through all these notices and having it be the excluding for the right reasons, okay? And there's a lot of convictions that come up that are not at all about your job, okay? And, the part of the state's belief, obviously, is that they served their time. Why are we still holding it against them in employment? So that's the reason for some of this. So this was a biggie when they changed it, and it really flew under the radar. It was changed in March last year. Okay? So thanks for asking that. And then lastly here, I already mentioned about the posters. So I'm doing okay. So that's the summary of the recent ones I wanted to make sure you guys are up on. And then moving on to issues that could be coming up at either the federal or the state level for Illinois. One is everybody, thought that COVID was over, right? And it just goes on and on and on. So we are still going to be dealing with whatever comes next with COVID. And out of that, there are all the work from home issues that companies are dealing with by having their employees that have jobs that it's feasible, right, for them to work from home. And it might have made sense to have somebody work from home, for 3 months when it started, the coffee table, whatever. Maybe now they've moved to the dining room table because now it's been a year and now the kids might not be in school again. So the issues that are coming from working at home have not really made it through the courts yet. We don't really know how these things are all going to pan out. But what many organizations are looking at is seeing how do we really support the fact that this is now happening. We're actually seeing companies paying folks more for their cable, okay? Obviously in Illinois, actually, you should already have been paying if an employee was using their personal cell phone for work. There has been an expense requirement for giving them $20 or something like that per month for using their personal cell phone for business. So cable is now coming out. We're actually seeing companies that are trying to hire people to work from home that say, hey, look at, if you have your spare bedroom that you're using as an office, we'll pay part of your rent or part of, the tax that you would have for a home office. We'll pay you towards that because we don't have an office now. We closed our big office. You're working from home. We're going to now contribute to the cost of your home. Well, there's tax implications in all these things that are coming, and we want to make sure that you figure this out. What if somebody falls on the stairs while they're at home? Is that workers' comp? Okay, so a lot of the issues from working at home are just now kind of rolling through. So we're going to be having lots of those in the future. Also, there's some companies that are watching their employees while they're working at home to see if they're actually working at home. It's called Tattleware, okay? And it's legal, but you have to notify the employee so that they know. Like if somebody says, yeah, I'm working at 8:30, and no, they're not. The little camera in your, they would know. Is that legal? I don't know. So some of these things are really going to be big in the next year, trying to figure out the legalities. I do want to point out Illinois has been trying to get a paid sick leave law for several years now. It is still just sitting out there with some of the for the pandemic payment for small companies. You had 2 weeks of pay that you had a tax credit for. Okay, now there's a lot of people asking that get reinstated now at the federal level. They're saying we need to have that back. All these people are sick. A lot of people are sick right now. So that has really kind of opened up the thought that paid sick leave would be something that would be mandated. So that is very possibly out there for Illinois next year. Unionization, oh my heavens. So at the federal level, part of the commitments that have been made are that union membership and unionization of non-union companies, some of the things that have been rules out there on protocol and how to do that are being wiped out if they can make it through Congress, making it much, much easier for employees to choose to unionize. So that would be a non-union company where the employees vote to say, hey, we want to have a union. So it's all going to be very, very fast and easy for the employees to do that. So if you're thinking, oh, we're non-union, our employees won't unionize, retail is getting unionized. You see Amazon, they're going after Walgreens, they're Walmart. So the unions are going into areas that you might commonly think, oh, that's not going to affect us. But that will be a lot of legislation, if they can get it through Congress, to support unionization. Also, another one of these ping pong laws was, what is the minimum salary that somebody can be paid to be salaried exempt? So, there's hourly employees, then you have salaried employees. Often those are what we call salaried exempt, meaning you don't pay them overtime. There's a minimum salary that you can pay somebody to have that status. Otherwise, they have to be hourly. So it was very, very low, like $24,000 a year until about 5, 6, 7 years ago, I don't know. During the Obama administration, they proposed to go to 47. Okay, that didn't get passed before the Obama administration was over. So when Trump came in, they lowered it. That never kind of hit. They have made it official at 35. So the current minimum that a salaried exempt employee can be paid is $35,568. Well, now we have the Biden administration, and the Biden administration is talking about raising that to the $47,476 that had been the original Obama administration level. So that would mean that if you have salaried exempt employees, you'd have to figure out about their pay. If you had them between $35,000 and $47,000, they could not be salaried exempt. Your choices would be to have them be salaried non-exempt, meaning that they get paid for overtime, so we're switching to hourly, or you raise their pay up to $47,000. So that is very possible. It's being talked about. I already talked about independent contractors, that there's a lot going on in that area. Part of the Obama and Trump back and forth during the Obama administration, they had created that if there was what's called joint employers, that they fell under the head company. So let's say I have a Holiday Inn that I own, and I'm just me. I'm not the owner. It's a franchise. A lot of these hotels out there are franchises. I own a Holiday Inn, but none of my employees work for the big Holiday Inn. They work for me. Okay. But under this joint employer legislation that they had during the Obama administration, it never quite kicked in fully because it was more like opinions at that point. But it would have said that even though my employees work for me, that whatever the rules are for the big Holiday Inn, that they're all part of one employer. So now Holiday Inn, all these people who own Holiday Inn hotels would be under their umbrella. Okay, it was a big deal for McDonald's and the McDonald's franchisees at the time. They were talking about, well, you're really an employee of McDonald's Corporation. And they were like, no, I'm Joe Blow and I own 2 McDonald's. They're my employees. They're not McDonald's Corporation employees. So this is back. And it also affects temp agencies, staffing firms. If you have employees that are with you from another organization, that also will impact on this. So that is out there. Whew. So that's my whole list. I don't know. I guess I'm probably over here. I do have at the bottom the name of the attorney that I have used for many, many years. Julie Procia with Smith Amundsen, a very, very good defense law firm. Defense means it defends companies. It's not for employees who sue companies. It's for companies. And you can contact her with any information you'd like from a lawyer. I'd be happy to answer any questions that you have that I can handle. I know this is a lot. Are there any questions?
I was just curious as to the reasoning why there's a limitation on asking applicants like their prior pay or benefits, like, just to have more knowledge of why.
Okay. So the question was, what's the rationale behind not asking an applicant about their prior pay? It's part of the concept that under equal pay issues, males have historically been paid more than females for the same kind of work. So the thought is that if we don't know what a male or a female makes historically, we would be less likely to offer the person who's paid lesser. Okay, so if somebody's thinking, oh, this is a woman, probably is married, has somebody else making money in the household, and they were making $15 an hour, even though I pay the other guy $18 an hour, I'm just going to offer her 15 because I can. Maybe she'll accept it. Okay, and there has been a lot of information that says that sometimes women don't negotiate as well for pay. So if we don't know that the woman was making 15, or what the guy was, and now we're offering them both 15 or 18, right? Who knows? Then it's done without that information. So the idea is that it would less perpetuate the difference in male and female pay.
In the same category, could you ask what their salary requirements are?
Yes.
Okay.
Yes, so the question was, can you ask what their salary requirements are? Yes, you can put in a posting what the pay range is. You can ask, if this is what we're looking at, is this okay? You can just specifically say, what do you want? And you can put that on the application form. What pay are you looking at? Yeah, and that would open up the conversation. It's kind of again, the whole thing is a conceptual idea that they've embraced as to how this might matter. Yes?
What's the difference between a mandate and a law? I may use them interchangeably.
Okay, so what's the difference between a mandate and a law? Yeah, in some cases they're the same thing. Sometimes, like for the sexual harassment training, that's a mandate, that's a law. So they're mandating you have to do this training. Okay. Mass mandate is executive order that was done by the governor. Okay, so an executive order is not a law, but under the authority of the governor, he can mandate certain behaviors and requirements.
So if an employee is not wearing a mask, I can be fined?
Yes. Yes. So the question is, if an employee's not wearing a mask, can I be fined $13,000? How much did I say? $13,653 if the employee's not wearing a mask. See? Per employee, per day, conceivably. Now that's the maximum. Often, if OSHA comes to your facility, usually they come to your facility in order to have a citation. Citation is the word they use for when they write you up for something. They usually come on site to catch you. They don't call you and say, hey, I'm coming, okay? But they have bigger fish to fry sometimes than a smaller business. So some of it has to do with how they pick. If they have a zillion phone calls, how do they figure out who to go visit? Now, during COVID last summer, they were making phone calls and saying, hey, we were told that you're not sanitizing properly. Those sanitizing rules are still out there, guys. Okay? And boy, oh boy, I think almost everybody's kind of fallen off. Many folks have fallen off some of the sanitation requirements. But any OSHA requirement under COVID has a exposure for $13,000 potentially. Yeah.
Will this include all of the mandates they have now for Cook County, like the vaccination requirements for restaurants and that kind of thing?
Yeah, so the question is about what about the requirement for Cook County or Chicago? Those are specific to the municipality. So the way employment law works is if there's a federal law, that would be the law unless a state or municipality has their own higher or better law. So the minimum wage is an example. So federally, the minimum wage is $7.25. But Illinois has their minimum wage now, okay? And then Cook County and Chicago have their own minimum wage, and they each override the other, as long as it's more beneficial to the employee. So for the requirements for restaurants in Cook County and Chicago, of course, their employees have the mask mandate in Illinois, whether they're in Chicago or anywhere. So all the employees are walking around with masks. You go into a restaurant now, the restaurants are being mandated that they have to look at vaccine cards, right? That's not an employment law so much as it is an executive order, in that case by the mayor of Chicago or the, I don't know what her title is, okay, sorry. Or it could be the governor for the state of Illinois. So it's kind of a who's in charge, kind of more like at the federal and state level, they're called executive orders. I don't actually know what they call them for Chicago and Cook County, but they're kind of the same thing. So sometimes there's a very specific, like you have to do something, that's a mandate. There are some places where somebody says, I was discriminated against, and it's a concept. The employee feels that they didn't get what they wanted, or somebody else got what they wanted, or, you know, they don't like me. And there's a whole variety of reasons that somebody might feel that they've been discriminated against. Some might be legit, some might be not what you would agree to. Okay, that is a law that is a concept about not discriminating, okay? But there's no mandate as part of it, other than you have a poster up that tells your employees that that law exists. So that's a law with no mandate, other than a poster. Because each is an individual claim based on the circumstances of each employee and their unique, you know, story and concern. So that's a law with no mandate, okay? OSHA might have a mandate that they say falls under OSHA, but the Supreme Court just decided that that exceeded OSHA's authority. So that was a mandate that never actually made it, but we thought it was going to make it. So I think that they're interchangeable in a way. Some of them are just things you have to do for a mandate versus a law. So I'm not sure that was real clear. Yeah, Sandy.
Our attorney advised us that a mandate carries the force of the law until it's challenged in court. I don't know if Joe would agree with that.
Well, there you go.
So
Yeah.
do we have to comply with the mandate?
Yeah, and the example would be this recent Supreme Court decision is that OSHA mandated that this was to be done. And then there were some judges who said, I don't think so, and put a hold on it, okay? So they put a stay on that mandate. And then it wound up getting to the Supreme Court who said, So well said, Sandy. I think we need to wrap it up. I need to, okay. Any other questions? Okay, good. It was my pleasure, thank you.